Hello everyone, and welcome to the September 2025 edition of My PIP Monthly. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case we will discuss is the recent unpublished opinion per curiam of the Court of Appeals that was issued on August 11, 2025 of Kathleen Naeyaert versus Auto Club Group Insurance Company. The second case law update is on the unpublished per curiam of the Court of Appeals that was issued on August 13, 2025 of Desiree Durga and Justin Durga versus MemberSelect Insurance Company. Lastly, we will focus our discussion on the trending topic in PIP litigation of owned vehicle exclusions. I will first give you a brief overview of the topic. And second, we will discuss a recent case related to the topic of Bronson Health Care Group, Inc. versus Farm Bureau General Insurance Company in Michigan, which is an unpublished opinion per curiam of the Court of Appeals issued on August 20th, 2025. The first case we will discuss is the recent unpublished opinion per curiam of the Court of Appeals that was issued on August 11, 2025 of Kathleen Naeyaert versus Auto Club Group Insurance Company. This case discusses a claim for vehicle modifications in a contract dispute and interpretation regarding same. In this case, the subject motor vehicle accident took place back in 1973 when plaintiff was only 16 years old and she sustained serious injuries. Since then, plaintiff has driven a modified van. Defendant Auto Club has, in turn, purchased two modified vans for plaintiff, once in 2004 and again in 2012. Notably, defendant entirely funded the purchases of both vans and not just the modifications. Plaintiff entered into two contracts with defendant in 2004 and 2012 relating to these purchased vans. These two contracts essentially indicated that plaintiff would receive a new vehicle every 7 years or 100,000 miles, whichever came first. In 2018, Defendant Auto Club refused to purchase a third modified van for plaintiff at her request, citing to the 2013 case of Admire versus Auto Owners Insurance Company. The Michigan Supreme Court in Admire held that the base price of a new modified van was not an allowable expense under the No-Fault Act because it is an ordinary transportation expense that is easily separate from modifications. Instead, the court held insurers are responsible only for the cost of modifications to a van that insured must procure on their own. In 2021, the second modified van purchased for a plaintiff back in 2012 was stolen. In 2021, plaintiff filed suit against defendant alleging that defendant failed to pay certain PIP benefits in violation of the No-Fault Act and that it breached contracts by failing to purchase a modified van for plaintiff. Notably, there is a clause in the 2012 agreement indicating that no claims of another van/motor vehicle could be made for 7 years from the date of delivery of the van to the insured. Plaintiff filed a claim with defendant for a new van sometime in or around 2018, which was before the 7 years were up. In December 2018, plaintiff was notified by defendant that pursuant to the Admire case, plaintiff would have to purchase her own vehicle, and defendant would then timely fund the modifications. When plaintiff's 2012 van was stolen in 2021, she had it for over 7 years, and at the time of trial, she had not purchased a new van herself. The trial court ultimately denied defendant's motion for directed verdict, which argued that defendant was not obligated to purchase a new van for plaintiff. After a bench trial, the trial court concluded that the plaintiff should prevail, finding that the parties' 2012 agreement regarding the second purchased van required that defendant purchase another new van for plaintiff. The trial court found that the agreement contained a latent ambiguity as to what the parties agreed to should plaintiff bring a claim for another van, and consequently the trial court looked to extrinsic evidence to conclude that defendant was obligated to purchase a new van. The parties then had to submit briefs to the court regarding the proposed amounts of damages for the cost of the new proposed van and required modifications only. Plaintiff was ultimately awarded over $47,000 in damages, which included prejudgment interest and some costs. This appeal followed. Ultimately, the Court of Appeals agreed with defendant that the trial court's ruling was erroneous. First, the court found that the trial court's framing of the purported ambiguity was error because there was no such latent ambiguity found in the contract. The appropriate inquiry is whether the agreement is patently ambiguous or ambiguous on its face, which the court did not find that to be true. Looking at the 2012 agreement as a whole, the parties certainly contemplated that defendant or even plaintiff might buy another van. However, nothing in the agreement could be read as obligating defendant to do so. The plain terms of the agreement are silent as to defendant's obligation to buy another van, which means it has no obligation under the agreement to do so. The Court of Appeals ultimately reversed and remanded for entry of judgment in favor of Defendant Auto Club. The second case law update I have for you focuses on the unpublished opinion per curiam of the Court of Appeals that was issued on August 13, 2025 of Desiree Durga and Justin Durga versus MemberSelect Insurance Company. This lawsuit relates to policy rescission and fraudulent misrepresentations. This case arises out of a motor vehicle accident that occurred in June 2023. Plaintiff Desiree Durga was driving a vehicle insured by defendant MemberSelect. The other plaintiff, Justin Durga, was also a passenger in the vehicle. Plaintiff Justin Durga's Michigan driver's license was mandatorily revoked on June 9, 2007 until certain requirements were met after having 2 or more substance abuse convictions. In June 2012, plaintiff Desiree Durga, who is Justin Durga's wife, applied for a policy with defendant, at which time she reported that she disclosed that plaintiff Justin Durga did not have a valid driver's license. However, the policy procurement documents submitted by MemberSelect appeared to demonstrate and assert that plaintiff Justin Durga was not licensed, unlicensed, and that he has 0 years licensed, and that he did not have a license, and all these statements appeared to contradict one another. With that, defendant MemberSelect sought rescission of the policy ab initio, arguing that these statements were all false material representations. The Durgas filed suit against defendant, claiming that defendant breached their automobile insurance contract when it rescinded their policy, based upon an allegation that Ms. Durga made a fraudulent misrepresentation in the application process. Notably, defendant was entirely unable to produce the original 2012 application for insurance at issue here, indicating that same had been lost. Instead, defendant relied on an affidavit of an underwriter who asserted that defendant's underwriting guidelines make material distinctions between a person being unlicensed or not licensed versus their license being revoked when it is acknowledged that plaintiffs never had access to these guidelines. Both the trial court and the Court of Appeals ultimately disagreed with defendant's choice to rescind the policy. The court did not find that any of the dictionary definitions it reviewed foreclose a person whose license has been revoked from being considered unlicensed or not licensed. The court noted that any perceived ambiguity in language is construed against the drafter in favor of coverage. In addition, referring to a person whose license has been revoked as unlicensed or not licensed is consistent with Michigan law. Defendant contended that Ms. Durga represented that her husband had 0 years licensed in her application in light of his license having been revoked in 2007. The court found that this does not constitute a false representation for purposes of establishing that prima facie element of claim for fraud in the application and rescission. The court further found that defendant's claim that responding 0 is the functional equivalent of indicating one has never been licensed to be without merit. Responding with a number of years based upon having been licensed during some past time period, while likewise indicating that they are not licensed due to revocation, would appear to be factually conflicting and inconsistent. Finally, as to rescission, the court held that not only has defendant not provided clear and convincing evidence of fraud in this case, it has provided no evidence of fraud, meaning it is not entitled to rescission. Ultimately, the trial court's order granting plaintiff's motion for summary disposition and denying defendant's cross motion for summary disposition was affirmed by the Court of Appeals. Finally, I want to discuss the trending topic in PIP litigation of owned vehicle exclusions contained within policies. In Michigan, owned vehicle exclusions refer to scenarios where a person is disqualified from receiving PIP benefits even if injured in a car accident involving a Michigan registered vehicle. The exclusions are based on specific sections of Michigan law, such as MCL 500.3113 subsection B, which outlines the requirement for an owner to maintain insurance to receive benefits. These exclusions include operating a stolen or unlawfully taken vehicle, being the owner or constructively owning an uninsured vehicle, being a non-resident without Michigan insurance, or being a named excluded driver under an insurance policy. These exclusions are designed to ensure that people with proper coverage receive benefits and to prevent those operating vehicles without required insurance from benefiting from the system. To go into a little more detail with these common owned vehicle exclusions, an owner of an uninsured vehicle, meaning if you are the owner or a constructive owner, someone who has the right to use a vehicle for more than 30 days, of the vehicle involved in the accident and it is uninsured, you are not eligible to receive no-fault PIP benefits. With unlawfully taken vehicles, you cannot claim PIP benefits if you are injured while operating or occupying a vehicle you knew or should have known was stolen or unlawfully taken. For non-resident without Michigan insurance, non-residents generally cannot receive PIP benefits unless they own a vehicle that is registered and insured in the state of Michigan. And lastly, a named excluded operator. If your name is on an insurance policy as an excluded operator and you are operating the vehicle at the time of the accident, you may be disqualified from receiving PIP benefits. Relating to this topic, I wanted to next bring up the recent case of Bronson Health Care Group, Inc. versus Farm Bureau General Insurance Company of Michigan, which is an unpublished opinion per curiam of the Court of Appeals issued on August 20th, 2025. In this case, the underlying claimant, Ray Forney, was involved in a motor vehicle accident in June 2021. After same, he received treatment from plaintiff provider Bronson Health Care Group, and he reported his no-fault insurer to be defendant Farm Bureau. Later, Mr. Forney stated that he had purchased an unladen liability insurance policy from Northwoods Insurance, Inc., when he leased the involved vehicle to a company for which he was working as a subcontractor. An unladen liability insurance policy provides coverage for damage or injuries to third party when a truck is not carrying a load of cargo, covering both situations where the truck is driving with an empty, attached trailer or deadheading, or without any trailer attached at all, or bobtailing. This coverage is often required by motor carriers to cover the owner-operator when the truck is not under dispatch, as the commercial policy may not cover these non-business activities. The Court of Appeals found that the policy issued by defendant Farm Bureau to Mr. Forney contained an owned vehicle exclusion that stated that defendant would not provide PIP benefits for bodily injury to, quote, to you while occupying or struck by while not occupying any auto owned or registered to you which is not your covered auto, unquote. The policy defined the word you as the named insured shown in the declarations, i.e. Mr. Forney. This exclusion denies PIP benefits when a named insured is injured in an accident involving an auto of which he is the owner or registrant that is not listed as a covered auto in the policy. It was undisputed that the involved vehicle being driven by Mr. Forney at the time of the accident was not a covered auto under the policy, and that Mr. Forney was the owner or the registrant of the involved vehicle. The Court of Appeals found the exclusion as somewhat narrower exclusion than that at issue in the case of MemberSelect Insurance Company versus Hartford Accident and Indemnity Co., in that it denies PIP benefits only when the named insured is the owner or registrant of the involved non-covered auto. Still, MemberSelect compels the same result. The Court of Appeals noted that Mr. Forney is entitled to PIP benefits from defendant unless another statutory provision deprives him of those benefits. Thus, defendant's policy language cannot override his or through him, plaintiff provider's, entitlement to these benefits. And the court found that the trial court erred by granting summary disposition to defendant on that basis. The Court of Appeals rejected defendant's alternative argument that plaintiff did not establish a genuine issue of material fact regarding whether the Northwoods insurance policy satisfied the requirements of MCL 500.3101 subsection 1. Although the evidence regarding the specifics of the Northwoods insurance policy was arguably somewhat thin, reasonable minds could differ regarding whether the policy satisfied the requirements of MCL 500.3101 subsection 1 and whether Mr. Forney and plaintiff are barred from recovering PIP benefits from any insurer. The Court of Appeals found that the trial court did not err by finding that a factual question existed regarding the coverage provided by the Northwoods policy. The Court of Appeals made no finding, however, as to whether the Northwoods policy does satisfy MCL 500.3101 subsection 1. Ultimately, the Court of Appeals reversed and remanded for further proceedings. That concludes the September 2025 edition of My PIP Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Kathleen Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topic in the PIP world. Take care, everyone.